The Select Committee to investigate the January 6th attack on the United States Capitol will be in order. Without objection, the chair is authorized to declare the committee in recess at any point. Pursuant to House Deposition Authority Regulation 10, the chair announces the committee's approval to release the deposition material presented during today's hearing. Good afternoon. In our previous hearings, the Select Committee showed that then President Trump applied pressure at every level of government, from local election workers up to his own vice president, hoping public servants would give in to that pressure and help him steal an election he actually lost. Today, we'll tell the story of how the pressure campaign also targeted the federal agency charged with enforcement of our laws, the Department of Justice. We already covered part of Mr. Trump's effort. We heard from Attorney General Bill Barr tell the story in the committee about the baseless claims Mr. Trump wanted the Justice Department to investigate, and that Mr. Barr viewed those claims as nonsense. Today, we'll hear from Jeffrey Rosen, the person Mr. Trump appointed to run the Justice Department after Attorney General Barr resigned. We'll hear from other senior Justice Department officials also. Together, these public servants resisted Mr. Trump's effort to misuse the Justice Department as part of his plan to hold on to power.
There is much more to come, both in our hearings and in our report. But I'd like to take just a moment to put everything we've seen in context. We have already seen how President Trump falsely declared victory on November 3rd, 2020, how he and his team launched a fraudulent media campaign that persuaded tens of millions of Americans that the election was stolen from him. Donald Trump intentionally ran false ads on television and social media, featuring allegations that his advisors and his Justice Department repeatedly told him were untrue. We have also seen how Donald Trump launched a fraudulent fundraising campaign that raised hundreds of millions of dollars, again, based on those same false election fraud allegations. We have seen how President Trump and his allies corruptly attempted to pressure Vice President Pence to refuse to count lawful electoral votes and obstruct Congress's proceedings on January 6th, and how he provoked a violent mob to pursue the Vice President and others in our Capitol. We've seen how the President oversaw and personally participated in an effort in multiple states to vilify, threaten, and pressure election officials, and to use false allegations to pressure state legislators to change the outcome of the election. We've seen how President Trump worked with and directed the Republican National Committee and others to organize an effort to create fake electoral slates, and later to transmit those materially false documents to federal officials, again as part of his planning for January 6th. We have seen how President Trump persuaded tens of thousands of his supporters to travel to Washington, D.C. for January 6th. And we will see in far more detail how the President's rally and march to the Capitol were organized and choreographed. As you can tell, these efforts were not some minor or ad hoc enterprise concocted overnight. Each required planning and coordination. A key focus of our hearing today will be a draft letter that our witnesses here today refused to sign. This letter was written by Mr. Jeff Clark with another Department of Justice lawyer, Ken Klukowski, and the letter was to be sent to the leadership of the Georgia State Legislature. Other versions of the letter were intended for other states. Neither Mr. Clark nor Mr. Klukowski had any evidence of widespread election fraud, but they were quite aware of what Mr. Trump wanted the department to do. Jeff Clark met privately with President Trump and others in the White House and agreed to assist the president without telling the senior leadership of the department who oversaw him. As you will see, this letter claims that the U.S. Department of Justice's investigations have, quote, identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. In fact, Donald Trump knew this was a lie. The Department of Justice had already informed the President of the United States repeatedly that its investigations had found no fraud sufficient to overturn the results of the 2020 election. The letter also said this, quote, "In light of these developments, the Department recommends that the Georgia General Assembly should convene in special session," end quote, "and consider approving a new slate of electors." And it indicates that a separate, quote, "fake slate of electors supporting Donald Trump has already been transmitted to Washington, D.C. For those of you who have been watching these hearings, the language of this draft Justice Department letter will sound very familiar. The text is similar to what we have seen from John Eastman and Rudy Giuliani, both of whom were coordinating with President Trump to overturn the 2020 election. When one of our witnesses today, Mr. Donahue, first saw this draft letter, he wrote this, quote, "This would be a grave step for the department to take, and it could have tremendous constitutional, political, and social ramifications for the country," end quote. This committee agrees. Had this letter been released on official Department of Justice letterhead, it would have falsely informed all Americans, including those who might be inclined to come to Washington on January 6th, that President Trump's election fraud allegations were likely very real. Donald Trump offered Mr. Clark the job of acting Attorney General, replacing Mr. Rosen, with the understanding that Clark would send this letter to Georgia and other states and take other actions the president requested. One other point. Millions of Americans have seen the testimony of Attorney General Barr before this committee. At one point in his deposition, the former Attorney General was asked why he authorized the Department of Justice to investigate fraud in the 2020 election at all. Why not just follow the regular course of action and let the investigations occur much later in time, after January 6th?
The Department of Justice is unique in the executive branch. The president cannot pervert justice nor the law to maintain his power. Justice must, both in fact and law, be blind. That is critical to our whole system of self-governance. During this hearing, you'll hear time and time again about the president's request to investigate claims of widespread fraud. Our witnesses, Mr. Rosen, Mr. Donahue, and Mr. Engel, stood firm in the face of overbearing political pressure because they understood that their oath was to the Constitution and not to the personal or political interests of the president. The president and his allies became keenly aware that with legal challenges exhausted and electoral votes certified, their only hope would be a last-ditch scheme to prevent Congress from certifying the win, thus throwing the entire system into constitutional chaos. The president wanted the department to sow doubt in the legitimacy of the election. His followers and members of Congress to take action. If the department could just lend its credibility to the conspiracies, people would have the justification they needed to spread the big lie. So President Trump ultimately wanted the Department of Justice to say the election was, quote, corrupt and, quote, leave the rest to me and the Republican congressmen. Let's look at what attorneys general, Democrats and Republicans alike, have said about upholding their oath to the Constitution.
Attorney General ultimately owes his loyalty to the integrity of the American people and to the fidelity to the Constitution and the legitimate laws of the country. That's what he's ultimately required to do.
I will be an independent Attorney General. I will be the people's lawyer.
The Attorney General's position as a cabinet member is perhaps unique from all of the cabinet members. Yes, a member of the President's cabinet, but the Attorney General has a unique responsibility to provide independent and objective advice to the President or any agency when it is sought, and sometimes perhaps even when it is not sought.
Everyone in that video, from Eric Holder to Jeff Sessions, spoke as one about the independence of the department. It's a point of pride at Justice to apply the law without the president's political self-interests tainting its actions or dictating how it uses its authorities. But President Trump did find one candidate at Justice who seemed willing to do anything to help him stay in power. Let's hear what President Trump's own lawyer, Eric Hirschman, had to say about Jeff Clark's plan to overturn the election. I'd like to advise viewers this video contains some strong language.
And when he finished discussing what he planned on doing, I said, good fucking, excuse me, sorry, a-hole. Congratulations, you just admitted a first step or act you take as Attorney General would be committing a felony and violating Rule 6C. You're clearly the right candidate for this job.
President Trump's campaign to bend the Justice Department to his political will culminated in a showdown on January 3rd. Today, we will take you inside that early evening Oval Office meeting where top Justice Department officials met with the president. At stake, the leadership and integrity of the Department of Justice.
I now recognize myself for questions. First of all, gentlemen, thank you for being here today. All of you served at former President Trump's pleasure at the Department of Justice in top leadership positions with tremendous responsibilities. Former Attorney General Bill Barr told the Select Committee that before he left the department in December 2020, he told President Trump on at least 3 occasions there was no evidence of widespread election fraud that would have changed the results of the presidential election, and refuted numerous specific claims of election fraud the president was making. Mr. Rosen, after Mr. Barr announced his resignation, did Donald Trump continue to demand that the Department of Justice investigate his claims of election fraud?
Yes, he asserted that he thought the Justice Department had not done enough.
Thank you. From the time you took over from Attorney General Barr until January 3rd, how often did President Trump contact you or the department to push allegations of election fraud?
So between December 23rd and January 3rd, the president either called me or met with me virtually every day, with 1 or 2 exceptions like Christmas Day. And before that, because I had been announced that I would become the acting Attorney General before the date I actually did, the president had asked that Rich Donahue and I go over and meet with him, I believe on December 15th as well.
So after you had some of these meetings and conversations with the president, what things did the president raise with you?
So the common element of all of this was the president expressing his dissatisfaction that the Justice Department, in his view, had not done enough to investigate election fraud. But at different junctures, other topics came up at different intervals. So at one point, he had raised the question of having a special counsel for election fraud. At a number of points, he raised requests that I meet with his campaign counsel, Mr. Giuliani. At one point, he raised the whether the Justice Department would file a lawsuit in the Supreme Court. At a couple of junctures, there were questions about making public statements or about holding a press conference. One of the later junctures was this issue of sending a letter to state legislatures in Georgia or other states. And so there were different things raised at different parts of, or different intervals, with the common theme being his dissatisfaction about what the Justice Department had done to investigate election fraud. I will say that the Justice Department declined all of those requests that I was just referencing because we did not think that they were appropriate based on the facts and the law as we understood them.
Thank you. So, Mr. Donahue, on December 15th, the day after Attorney General Barr announced his resignation, the president summoned you and Mr. Rosen to the White House. At this meeting with the president, what did he want to discuss?
There were a number of topics of discussion that day, Mr. Chairman. Much of the conversation focused on a report that had been recently released relating to Antrim County in Michigan. I believe on December 13th, an organization called the Allied Security Group issued a report that alleged that the Dominion voting machines in that county had a 68% error rate.
Thank you. Mr. Engel, we know that Attorney General Barr announced on December 1st, 2020, that the Department of Justice had found no evidence of widespread fraud that could have changed the outcome of the election. So from December 1st, 2020 until today, as you sit here, have you ever doubted that top line conclusion?
No, I've never had any reason to doubt Attorney General Barr's conclusion.
Thank you. Pursuant to Section 5C8 of House Resolution 503, the chair now recognizes the gentleman from Illinois, Mr. Kinzinger, for questions.
Thank you, Mr. Chairman. In the weeks leading to January 6th, the Department of Justice was fielding almost daily requests from the president to investigate claims of election fraud. Each claim was refuted time and time again, an effort Attorney General Barr described as whack-a-mole. When each of the president's efforts failed, he resorted to installing a new attorney general to say the election was illegal and corrupt, simply so he could stay in power. President Trump started leaning on the Justice Department the first chance he got. On November 29th, his first television interview after the election.
Where is the DOJ and the FBI in all of this?
Republican congressmen echoed the president just 2 days later. They wrote a letter to Attorney General Barr laying into the Justice Department for a, quote, shocking lack of action in investigating the claims of election fraud. That same day, Attorney General Barr stated publicly that President Trump's claims had no merit. Ignoring the top law enforcement officer in the country, Republican congressmen amplified the stolen election message to the American public. Let's listen.
And so there's widespread evidence of fraud because people haven't done their jobs. Durham and Barr will deserve a big notation in history when it's written of the rise and fall of the United States if they don't clean up this mess, clean up the fraud, do your jobs, and save this little experiment in self-government.
Right now, as we can see on the screen, you actually quote President Trump asking, where's DOJ, just like we heard him say in his first television interview. How did you respond to that?
So both the acting AG and I tried to explain to the president on this occasion and on several other occasions that the Justice Department has a very important, very specific, but very limited role in these elections. States run their elections. We are not quality control for the states. We are obviously interested in and have a mission that relates to criminal conduct in relation to federal elections. We also have related civil rights responsibilities, so we do have an important role. But the bottom line was if a state ran their election in such a way that it was defective, that is to the state or Congress to correct. It is not for the Justice Department to step in. And I certainly understood the president as a layman not understanding why the Justice Department didn't have at least a civil role to step in and bring suit on behalf of the American people. We tried to explain that to him. The American people do not constitute the client for the United States Justice Department. The one and only client of the United States Justice Department is the United States government. And the United States government does not have standing, as we were repeatedly told by our internal teams, OLC led by Steve Engel, as well as the Office of the Solicitor General, researched it and gave us thorough, clear opinions that we simply did not have standing. And we tried to explain that to the president on numerous occasions.
So let's now put up the notes where you quote the president. As you're speaking to that, he said, the president said, just say the election was corrupt and leave the rest to me and the Republican congressman. So, Mr. Donahue, that's a direct quote from President Trump, correct?
That's an exact quote from the president, yes.
The next note shows that even that the president kept pressing, even though he'd been told that there was no evidence of fraud. Did the president keep saying that the department was, quote, obligated to tell people that this was an illegal, corrupt election?
That's also an exact quote from the president. The president throughout all of these meetings and telephone conversations was adamant that he had won and that we were not doing our job. But it did escalate over time until ultimately the meeting on January 3rd, which was sort of the most extreme of the meetings and conversations.
So I want to make sure we don't gloss this over. Just say it was corrupt and leave the rest to us. The president wanted the top Justice Department officials to declare that the election was corrupt, even though, as he knew, there was absolutely no evidence to support that statement. The president didn't care about actually investigating the facts. He just wanted the Department of Justice to put its stamp of approval on the lies.
But when I hung up, I was quizzical as to how does the president even know Mr. Clark? I was not aware that they had ever met or that the president had been involved with any of the issues in the civil division.
So it was a bit of a surprise when he brought his name up?
Yes.
So Mr. Clark was the acting head of the Civil Division and head of Environmental and Natural Resources Division at the Department of Justice. Do either of those divisions have any role whatsoever in investigating election fraud, sir?
No. And to my awareness, Jeff Clark had no prior involvement of any kind with regard to the work that the department was doing that Attorney General Barr has talked about to this committee.
So let's take a minute and explain why the president mentioned Jeff Clark's name to Mr. Rosen here on Christmas Eve. On December 21st, some Republican members of Congress met with President Trump in the White House to talk about overturning the 2020 election. Let's hear Representative Marjorie Taylor Greene talk about how this meeting got set up.
I was the only new member at the meeting. I called President Trump on Saturday and said, we've got to have a meeting. There's many of us that feel like this election has been stolen.
So on the screen, you'll see that President Trump's Chief of Staff, Mark Meadows, tweeted about that meeting right after it happened. He said, quote, several members of Congress just finished a meeting in the Oval Office with President Donald Trump, preparing to fight back against mounting evidence of voter fraud. Stay tuned. On the same day he met with these Republican members of Congress, President Trump called into a conservative political convention, and he used the opportunity to pressure the Department of Justice to investigate his bogus claims.
The problem is we need a party that's going to fight, and we have some great congressmen and women that are doing it, and we have some great fighters, but we won this in a landslide. They know it, and we need backing from, like, the Justice Department, and other people have to finally step up.
Is there a policy that governs who can have contact directly with the White House?
Yes. So across many administrations for a long period of time, there's a policy that, particularly with regard to criminal investigations, restricts at both the White House end and the Justice Department end those more sensitive issues to the highest ranks. So for criminal matters, the policy for a long time has been that only the Attorney General and the Deputy Attorney General from the DOJ side can have conversations about criminal matters with the White House, or the Attorney General and the Deputy Attorney General can authorize someone for a specific item with their permission, but the idea is to make sure that the top rung of the Justice Department knows about it and is in the thing to control it and make sure only appropriate things are done.
Mr. Ringo, from your perspective, why is it important to have a policy like Mr. Rosen just discussed?
Well, it's critical that the Department of Justice conducts its criminal investigations free from either the reality or any appearance of political interference. And so people can get in trouble if people at the White House are speaking with people at the department. And that's why the purpose of these policies is to keep these communications as infrequent and at the highest levels as possible, just to make sure that people who are less careful about it, who don't really understand these implications, such as Mr. Clark, don't run afoul of those contact policies.
Thank you. So the Select Committee conducted an informal interview with the White House counsel, Pat Cipollone, and his deputy, Pat Philbin, about their contact with Mr. Clark, though neither has yet agreed to sit for transcribed and videotaped interviews. But Pat Cipollone told the Select Committee that he intervened when he heard Mr. Clark was meeting with the president about legal matters without his knowledge, which was strictly against White House policy. Mr. Cipollone and Mr. Philbin, like Mr. Rosen, told Mr. Clark to stand down, and he didn't. On the same day, Acting Attorney General Rosen told Mr. Clark to stop talking to the White House, Representative Perry was urging Chief of Staff Mark Meadows to elevate Clark within the Department of Justice.
I certainly remember very specifically the conversation in the meeting on January 2nd. That got even more confrontational, but he was defensive and, similar to his earlier reaction when I said this is nothing less than Justice Department meddling in an election. His reaction was, I think a lot of people have meddled in this election. And so he kind of clung to that and then spewed out some of these theories, some of which we'd heard from the president, but others which were floating around the internet and media, and just kept insisting that the department needed to act and needed to send those letters.
The committee has also learned that Mr. Clark was working with another attorney at the department named Ken Klukowski, who drafted this letter to Georgia with Mr. Clark. Mr. Klukowski had arrived at the department on December 15th with just 36 days left until the inauguration. He was specifically assigned to work under Jeff Clark. And Mr. Klukowski also worked with John Eastman, who we showed you at our hearing last week was one of the primary architects of President Trump's scheme to overturn the election. The Georgia letter that we've been discussing specifically talks about some of Dr. Eastman's theories, including, quote, the purpose of the special session the department recommends would be for the General Assembly to determine whether the election failed to make a proper and valid choice between the candidates, such that the General Assembly could take whatever action is necessary to ensure that one of the slates of electors cast on December 14th will be accepted by Congress on January 6th. Committees also learned that the relationship between Dr. Eastman and Mr. Klukowski persisted after Mr. Klukowski joined the Justice Department. Let's take a look at an email recommending that Mr. Klukowski and Dr. Eastman brief Vice President Pence and his staff. Other recipients of this email included the Chief of Staff to Congressman Louis Gohmert. And the email says, as stated last week, I believe the Vice President and his staff would benefit greatly from a briefing by John and Ken. As I also mentioned, we want to make sure we don't overexpose Ken given his new position. This email suggests that Mr. Klukowski was simultaneously working with Jeffrey Clark to draft the proposed letter to Georgia officials to overturn their certified election and working with Dr. Eastman to help pressure the Vice President to overturn the election. I want to thank all of our witnesses for being here today and for answering our questions about this letter and other issues. We asked Mr. Clark some of the same questions that we've asked you, and here's how he answered.
Did you discuss this draft letter to Georgia officials with the President of the United States?
Fifth, and executive privilege, again, just restated for the abundance of caution.
If you look again at the draft letter, in the first paragraph, second sentence says, the department will update you as we are able on investigatory progress, but at this time we have identified significant concerns that may have impacted the outcome of the election in multiple states, including the state of Georgia. Isn't that in fact contrary to what Attorney General Barr had said on December 1st, 2020?
Yes.
One of the Attorney General's most important responsibilities is to provide legal advice to the President and to the executive branch. As a practical matter, given the responsibilities of the Attorney General, the Assistant Attorney General for the Office of Legal Counsel exercises that job on a day-to-day basis. And so, in addition, the head of OLC often functions as a general counsel, essentially to the Attorney General, and so is often, the chief legal advisor to the AG, as well as, the White House and the executive branch more broadly.
So given that role, can you kind of describe your relationship with the President?
Well, in connection with my role at OLC, over the course of my tenure there were a number of instances in which folks at the White House would seek to bring me in to provide legal advice to the President, sometimes discussing the legal options that could be pursued among various to reach various policy objectives, sometimes to advise the President that a course of action that they had been discussing was not legally available.
So I want to ask you about two things the President asked you and the department to do. The first is reflected in this email that we're going to put on the screen. The President sent a draft lawsuit to be filed by the department in the Supreme Court. He wanted you, Mr. Rosen, and Mr. Cipollone specifically to review it. You and the department opposed filing it.
And the acting attorney general asked me to prepare a memo with talking points so that he could explain our reasons when he spoke with the president about this.
So would you say it was an unusual request?
Certainly, you said the request that the department file a lawsuit from drafted by outside lawyers was certainly an unusual request.
There was another issue you were asked to look into. In mid-December, did the White House ask Attorney General Barr to consider whether a special counsel could be appointed to look into election fraud issues?
Yes. I mean, I think the president was probably vocal at the time that he believed that special counsel was something that should be considered to look into election fraud, and there is a specific, request where the Attorney General sought my legal advice in the middle of December.
And what was your conclusion? What conclusion did you reach?
So this request was whether the Attorney General could appoint as a special counsel a state Attorney General to conduct an investigation. I mean, as a legal matter, under federal law, the Attorney General actually has fairly wide discretion to delegate prosecutorial authority, including to state prosecutors, which happens to assist the department, and not uncommonly, obviously, a state Attorney General exercising prosecutorial authority on behalf of the Department of Justice would be fairly uncommon. When we looked at the issue, what we saw is actually that the state law, the state was Louisiana, that the state law precluded the Louisiana Attorney General from accepting any position, any official position on behalf of the United States government. So that answered the question that it was not legally available.
So during your time at the department, was there ever any basis to appoint a special counsel to investigate President Trump's election fraud claims?
Well, neither Attorney General Barr nor Acting Attorney General Rosen did appoint a special counsel. You would appoint a special counsel when the department, when there's a basis for an investigation and the department essentially has a conflict of interest. It's important to get someone who's independent outside the department to handle such an investigation. Neither Attorney General Barr nor Acting Attorney General Rosen ever believed that that was appropriate or necessary in this case.
In fact, Attorney General Barr had already told the president that there was no need for this special counsel. He actually stated that publicly, and we'll see that here in a video from December 21st.
To the extent that there's an investigation, I think that it's being handled responsibly and professionally currently within the department, and to this point I have not seen a reason to appoint a special counsel, and I have no plan to do so before I leave.
So remember that December 21st was the same day President Trump met with Republican members at the White House to strategize about how to overturn the election, while his Attorney General is out telling the public, again, that there was no widespread evidence of election fraud. And yet, 2 days later, we have President Trump tweeting, again publicly pressuring the department to appoint a special counsel. He said, quote, "After seeing the massive voter fraud in the 2020 presidential election, I disagree with anyone that thinks a strong, fast, and fair special counsel is not needed immediately. This was the most corrupt election in the history of our country, and it must be closely examined." The Select Committee's investigation revealed that President Trump went as far as to promise the job of special counsel to now discredited former Trump campaign lawyer Sidney Powell at a late-night meeting on December 18th. An investigation led by a special counsel would just create an illusion of legitimacy and provide fake cover for those who would want to object, including those who stormed the Capitol on January 6th. All of President Trump's plans for the Justice Department were being rebuffed by Mr. Rosen, Mr. Donahue, Mr. Engel, and others. The president became desperate entering into the new year with January 6th fast approaching. President Trump rushed back early from Mar-a-Lago on December 31st and called an emergency meeting with the department's leadership. Here's Mr. Donahue describing the last-minute meeting held at the White House on New Year's Eve.
The president was a little more agitated than he had been on the meeting, in the meeting on the 15th. He discussed a variety of election matters. He did say, this sounds like the kind of thing that would warrant appointment of a special counsel.
Mr. Donahue, during this meeting, did the president tell you that he would remove you and Mr. Rosen because you weren't declaring there was election fraud?
Toward the end of the meeting, the president again, was getting very agitated, and he said, people tell me I should just get rid of both of you. I should just remove you and make a change in the leadership, put Jeff Clark in, maybe something will finally get done. And I responded, as I think I had earlier in the December 27th call, Mr. President, you should have the leadership that you want, but understand, the United States Justice Department functions on facts, evidence, and law, and those are not going to change. So you can have whatever leadership you want, but the department's position is not going to change.
The Select Committee confirmed that a call was actually placed by Secretary Miller to the attaché in Italy to investigate the claim that Italian satellites were switching votes from Trump to Biden. This is one of the best examples of the lengths to which the President Trump would go to stay in power. Scouring the internet to support his conspiracy theories shown here, as he told Mr. Donahue in that December 27th call, quote, "You guys may not be following the internet the way I do." President Trump's efforts to this point had failed. Stonewalled by Mr. Rosen and Mr. Donahue, President Trump had only one option. He needed to make Clark acting Attorney General. Mr. Rosen, during a January 2nd meeting with Mr. Clark, did you confront him again about his contact with the president? And if so, can you describe that?
So at this point, Mr. Clark had told us that the president had asked him to consider whether he would be willing to replace me, supposedly on a timetable by Monday, the 4th. And so I had told Mr. Clark I thought he was making a colossal error in judgment, but I also hoped to persuade him to be more rational and to understood what we had understood, that there's not a factual basis for the fraud assertions that are being made. So at this meeting, Mr. Donahue and I met with Mr. Clark, and I guess my hopes were disappointed in that Mr. Clark continued to express the view that he thought there was fraud, even though he had not been a participant in the department's review of that, and that he was dissatisfied that we knew what we were doing. So, but he had acknowledged that he had had further, I don't know if it was meeting or phone calls or what, but further discussion with the president, despite having, a week earlier said that if he wouldn't do that, and if he did, if he got an invitation to do that, he would let Rich Donahue or me know. So it was a contentious meeting where we were chastising him that he was insubordinate, he was out of line, he had not honored his own representations of what he would do, and he raised again that he thought that letter should go out, and we were not receptive to that. Mr. Engel, I called at home and asked him if he would come in and go to the meeting, which he did. It proved to be quite helpful. And then number 4, I asked Rich Donahue and Pat Hovakimian, who had previously been my chief of staff, to get the department's senior leadership on a call and let them know what was going on, and which they did. And then Eric Hirschman called me to tell me that he was going to go to the meeting and that he would be supporting the Department of Justice position as well. So I knew that the meeting was on course and that I would have a number of people supportive of the Department of Justice's approach and not supportive of Mr. Clark's approach.
Did Mr. Clark ask you to continue to stay at the department?
At that Sunday meeting, when he told me that he would be replacing me, he said that he had asked to see me alone, because usually he had met with me and Mr. Donahue, because he thought it would be appropriate in light of what was happening to at least offer me that I could stay on as his deputy. I thought that was preposterous. I told him that was nonsensical and that there's no universe where I was going to do that, to stay on and support someone else doing things that were not consistent with what I thought should be done. So I didn't accept that offer, if I can put it that way.
But at this point, I asked the acting AG, what else can I do to help prepare for this meeting at the Oval Office? And he said, you and Pat should get the AAGs on the phone, and it's time to let them know what's going on. let's find out what they may do if there's a change in leadership, because that will help inform the conversation at the Oval Office. Pat Hovakimian subsequently set up that meeting. We got most, not all, but most of the AAGs on the phone. We very quickly explained to them what the situation was. I told them, I don't need an answer from you right now. I don't need an answer in this phone call, but if you have an answer, I need it in the next few minutes. Early on, the president said, what do I have to lose? And it was actually a good opening, because I said, Mr. President, you have a great deal to lose. And I began to explain to him what he had to lose, and what the country had to lose, and what the department had to lose. And this was not in anyone's best interest. That conversation went on for some time. Everyone essentially chimed in with their own thoughts, all of which were consistent about how damaging this would be to the country, to the department, to the administration, to him personally. And at some point, the conversation turned to whether Jeff Clark was even qualified, competent to run the Justice Department, which in my mind, he clearly was not. And it was a heated conversation. I thought it was useful to point out to the president that Jeff Clark simply didn't have the skills, the ability, and the experience to run the department. And so I said, Mr. President, you're talking about putting a man in that seat who has never tried a criminal case, who's never conducted a criminal investigation. He's telling you that he's going to take charge of the department, 115,000 employees, including the entire FBI, and turn the place on a dime and conduct nationwide criminal investigations that will produce results in a matter of days. It's impossible, it's absurd, it's not going to happen, and it's going to fail. That comment clearly had an impact on the president. The leadership will be gone. Jeff Clark will be left leading a graveyard.
Again, the premise that, which as Mr. Donahue has said, but that Mr. Clark could come in and take over the Department of Justice and do something different was just an absurd premise. And all he was doing, Mr. Clark, by putting himself forward, was blowing himself up. And, you know, if the president were to have gone that course, you know, it would have been a grievous error for the president as well.
Mr. Cipollone, the White House counsel, told the committee that Mr. Ingalls' response had a noticeable impact on the president, that this was a turning point in the conversation. Mr. Donahue, towards the end of this meeting, did the president ask you what was going to happen to Mr. Clark?
He did. When we finally got to the, I would say the last 15 minutes of the meeting, the president's decision was apparent. He announced that Jeff Clark tried to scrape his way back and asked the president to reconsider. The president doubled down, said, no, I've made my decision.
And they kept up the pressure campaign on the way to storming the Capitol on January 6th. Mr. Rosen, were you at the Department of Justice on January 6th?
Yes, I was there all day.
Once the Capitol was under attack, I understand that you communicated with fellow cabinet members and Capitol Hill leadership. Did you speak to the vice president that day?
Yes, twice.
No, please go ahead.
Well, I was going to say the first call was a one-on-one discussion, somewhat akin to the congressional leadership calls, updating him on what we were doing to assist. And the second call was a conference call around 7 o'clock with the vice president, congressional leaders, senior White House staff, some other cabinet officials, to address that order appeared to be close to being restored, but security still being determined, and the question being what time could the Congress reassemble. And the answer was 8 o'clock, and thankfully Congress did reassemble and complete its constitutional duty. There was one highlight of that second call with the vice president, which is Mr. Donahue had gone to the rotunda of the Capitol to be able to give firsthand account and was able to tell the folks on the call, including the vice president, that we thought 8 o'clock would work.
Did you speak to the president on January 6th?
No, I spoke to a number of senior White House officials, but not the president.
Without objection, the chair recognizes the gentleman from Illinois for a closing statement.
Thank you, Mr. Chairman. The Justice Department lawyers are not the president's personal lawyers. We count on them to be on the side of the law and to defend the best interest of the United States, not the best interest of any political campaign. The conspiracy theories were false. The allegation of a stolen election was a lie. The data left no room for doubt, nothing to question. And the Constitution left no room for President Trump to change the outcome of the election.
We are committed to presenting the American people with the most complete information possible. That will be our aim when we reconvene in the coming weeks. The chair, however, requests those in the hearing room remain seated until the Capitol Police have escorted members from the room. Without objection, the committee stands adjourned.